district attorney had what I called in my arguments sort of unusual, attenuated theories of guilt that had to do with my client not being the direct perpetrator of the sex acts in the case. She was charged alternatively as an aider and abettor, or as the employer of an innocent agent. An innocent agent's like a dupe. You know, like if I ask you to carry my attaché case to Colombia, and I tell you it's only got papers in it and it turns out to have a kilo of cocaine, you are my innocent agent. So yes, your question recognizes that my client did not penetrate personally, did not sexually assault personally any of the children, and the district attorney employed, as I said, what I call attenuated theories of liability. Nonetheless, the jury convicted her of those. There were 4 of those counts. 2 of them were misdemeanor and 2 of them were felony.
Why was it so important for you to only focus on certain of the charges in your closing arguments in defense? And what does that say that they all ended up coming back in this case guilty?
Well, it says that there are multiple reasons. Some of them are technical, having to do with the import of the strikeable allegations, right? We fought the strikes, for one thing. The strikes affect the percentage of time that the litigant has to serve in custody. The other thing is that we attacked a weak, attenuated theory of liability, right? On 4 of the 5 counts that were sex counts, as this gentleman just recognized with this question, my client was not the direct perpetrator. That's unusual, right? I've been doing this for about 28 years. I've never, ever done a trial where a sex offender was charged as an aider and abettor or was charged as the perpetrator via the use of an innocent agent theory. And I think it's clear. We told the jury that's why we went to trial on this case. We went to trial on this case not because we were trying to say that my client didn't contribute or provide any of this alcohol. And that's the answer to the second half of your question. The reason why we effectively conceded the bulk of this case in the opening statement and only fought some counts in a very general sense is because we thought that we would lose credibility with the jurors if we tried to present a defense that denied that my client provided alcohol. We think that what happened was a progression of the provision of alcohol. We think what actually happened was at the beginning, my client wasn't providing alcohol at all. And we think that in the beginning, there were multiple places where the children were going where alcohol was provided. What ended up happening, though, ultimately was because the path was so easy at the O'Connor household that those other locations were dispensed with and all the alcohol imbibement happened, or not all, but much of the alcohol imbibement happened at the O'Connor household. And so while we thought that the district attorney's theory, which was essentially all bad all the time, as bad as you could imagine it, wasn't entirely accurate, we didn't think that dying on the hill of Mrs. O'Connor didn't provide the alcohol at the first party, right? There was credible testimony about the first party that the children snuck the alcohol out of the liquor cabinet. My client didn't know anything about it. The district attorney quibbled with that, and that's fine. But as a tactical proposition, what we were faced with was standing in front of a jury and telling them that my client didn't provide the alcohol, and we didn't think that that was a smart thing to do. You know, we thought that, as I said, that was a credibility challenging position to take. And so we consistently identified the 5 counts in the beginning of the case that we thought we would defend, and the way that I explained it to the jury was specifically, we would defend these 5 counts specifically. Those had to do with the 4 sex counts and the 1 dissuading a witness count, which we thought failed with regard to the evidence. The jury obviously disagreed. And then the other counts that we fought, we described to the jury that we defended them more in a general sense, because there were the child endangerment counts had a contingency about them, right? They were serious if the jury found the victims to be in danger for their life and limb, essentially. And they were not as serious if the jury found that the children were not in danger for their life and limb. Essentially, great bodily injury is the phrase, the term of art. The jury agreed with us on 4 of those, right? Where the district attorney had charged in 4 separate incidences that the children were in danger of great bodily injury or death, where they followed our suggestion that, in fact, they were not in danger for great bodily injury or death. And while I appreciate that, as I said, it wasn't central to the 5 counts that we defended, and at the end of the day, it helps a little bit, but not a lot.
How was Ms. O'Connor feeling after the verdict came down? Did she say anything to you? Did she say
She's crushed. She's very, very disappointed. Yeah, I don't think I could say it any better than that. I'm not going to say what she said to me, but she said some things to me as the verdicts were progressing that made me understand that she was deeply disappointed in the decision.